Thursday, August 13th. Commissioner Martz, would you like to lead us in the Pledge of Allegiance, please?
Sure. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Going on to item 3, Mr. Secretary, can we have a roll call, please?
Commissioner Charity? Absent. Commissioner Kirby's?
Aye, we're here.
Commissioner Maggio? I believe you're muted, Commissioner Maggio.
Okay.
There you go.
Am I here?
Yes.
Can you hear me now?
Yes.
Yes.
Okay, thank you.
Commissioner Martz?
present.
Commissioner O'Keefe?
Here.
Vice Chair Topshin?
Here.
Chair Bergstein?
Present, so we have a quorum. Moving on to item 4, approval of tonight's agenda. Have we all had a chance to review tonight's agenda? If you have any comments or changes, if not, I'll entertain a motion to accept as submitted.
I'll make a motion to approve the agenda for this evening.
I will second that.
Mr. Secretary, we have a roll call vote, please.
Commissioner Charity absent. Commissioner Kirby's?
Aye.
Commissioner Maggio?
Here, yes.
Commissioner Martz?
Yes.
Commissioner O'Keefe?
Aye.
Vice Chair Topshin?
Aye.
Chair Bergstein?
Aye. So the agenda is approved. Moving on to item 5, approval of the minutes from the July 23rd Rent Stabilization Commission meeting. You all had a chance to review that. Do you have any revisions or changes? Commissioner O'Keefe?
I have a minor one. On item 10, it says motion fails by a vote of 4-3. Usually the yes votes are listed first, so I just suggest swapping it to 3-4. That's it.
With that minor adjustment, any other changes to the minutes? If not, entertain a motion to accept as revised.
Motion to move the agenda with the amendment.
It's the minutes, not the agenda.
I mean, sorry, minutes.
Thank you. Is there a second?
Second?
Thank you. Secretary, can we have a roll call vote, please?
Commissioner Charity absent. Commissioner Kirby's?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Commissioner O'Keefe?
Aye.
Vice Chair Topshin?
Aye.
Chair Bergstein?
Aye. Passes. Going on to item 6, Mr. Secretary, do we have any public comments this evening?
No public comments at this time.
Thank you. On to item 7, manager report. Mr. Noonan, fresh back from vacation.
Thank you. It's good to be back, and it's nice to see all of you. So to start, I'd like to review the look ahead calendar, which is on page 8 of the agenda packet. And looking ahead, we do have 3 appeals for this evening. And at the next meeting in August, on the 27th, we have 2 appeals that night. September 10th, we also have 2 appeals. And so on those 2 nights, we will not be scheduling any other items given the number of appeals. On September 24th, we have 1 appeal scheduled at this time, and we have scheduled information on subletting under the RSO. On October 8th, we do not have any appeals scheduled yet, and so we have scheduled that evening information on the RSO deposit interest formula and a discussion on broken elevators, which was at the request of the commission. At this time, I'm looking to swap the information on the RSO deposit interest formula, so that will be received by the commission on the 24th of September. And then the information on subletting under the RSO would be received on October 8th. Commissioners, in your comments, you could let me know if you see any issues with that. Now, as part of my report, I would like to share my screen and briefly walk through some of the information that we have on our website that's related to the eviction moratorium that's in place right now at the city and the prohibition on rent increases. So this is for the commission and for members of the public. We do have a banner at the top of all of our pages at the West Hollywood website. That's www.weho.org. If you click on the coronavirus, this will bring you to the main coronavirus page that includes a number of resources available for the community related to the pandemic, support and services available, and rules and requirements. So the two that I'll focus on here today are the renter resources page and the resident resources page. On the renter resources page, this is really information that is available for renters and for landlords. And this is related to rental housing under the and the rules and requirements under the eviction moratorium that's currently in place and has been in effect since March 16th. Now, currently that eviction moratorium is set to expire September 30th unless further extended by the City Council. Related to the eviction moratorium, we do have a lot of information here, as I mentioned. We have a booklet that provides guidance on what a tenant can do if they're financially impacted due to the coronavirus pandemic. This brochure is in English, it's in Russian, and it's in Spanish. Importantly, tenants need to notify their property owner within 30 days of the rent being due if they're going to claim delayed rent under the eviction moratorium. They would need to state the financial impacts are related to COVID-19 and provide within 30 days documentation that establishes that impact. Now, prior to August 1st, a tenant could provide only an explanation with no supporting documents. However, August 1st and September 1st, tenants would need to provide documentation to substantiate their request, their claim. Now, on our main page, the again on the renter resources page, we do also, underneath the booklet on the eviction moratorium, we do provide a video guidance for multifamily housing, realizing that as LA County begins to lift the safer at home orders and to take a phased approach to reactivating local economies, it's really important to understand what the current recommendations are to keep you safe. And this includes information, as you can see under this tab here, information, links, and resources to across all of the county's public health guidance orders, including guidance on for multifamily buildings, safe operation of pools, common areas, and other guidance. So in addition to the information on guidance for multifamily housing, we do list all of the urgency ordinance along with the important dates that have been adopted by the council. And those are available here with a short description, the date that it was adopted, a short description, and a link to the actual ordinance itself. We have information on, again, on what affected tenants must do. This repeats the information that was in the booklet, but just in a different form. We have information on paying the rent delayed during COVID-19 and the importance that rent is delayed, it's not forgiven, and it does need to be repaid within 12 months following the end of the eviction moratorium. We do encourage property owners and tenants to have conversations about how rent should be repaid, but there's no requirement at this time that a tenant signs any kind of a repayment plan. We do have information on utility assistance and a list of healthcare providers on this page. Now, underneath, and then of course the guidance on multifamily housing. Now the end section is frequently asked questions, and an important question here is, what is the temporary eviction moratorium? The response here does capture all of the language that's in effect under the moratorium right now as it is. So if someone needs to understand and read through the moratorium, they can certainly read this FAQ. And of course, staff in the Rent Stabilization and Housing Division are also available on our information lines and can help and assist tenants and property owners to understand the requirements of the law. Our information lines are 323-848-6450 and rsh@weho.org. Now, the remaining list of frequently asked questions does provide a lot of information and answers to questions that may come up. This is an important one here, which is there a prohibition on rent increases? And right now there is. That rent increase prohibition, it applies to units that are subject to the rent limitations of the city's rent stabilization ordinance. And it began on April 6th, and it is in effect through 60 days after the local emergency declaration is ended by the city council. Now, this is a different date than the eviction moratorium, and I think that that's important for people to note, that the emergency period was declared by resolution on March 16th, just as the eviction moratorium was put into place by ordinance. They're separate vehicles. And so when the eviction moratorium does end, the emergency period may not. And at this point, the city council is reviewing the emergency declaration, and we have no indication that they have looked at a date for ending that. And so that will be in effect until the council declares that the local emergency is over. And after that happens, rent increases would be possible 60 days following. Now, I'm not going to go into more detail on the questions here, but I'll pause and conclude my manager's report now and allow commissioners to ask questions if they have those related to the information that we have on the website.
Commissioners, any questions? I have one, and Mr. Noonan, I emailed you this earlier in the week. What is the concern if a tenant is not in compliance with the terms of the eviction moratorium, if they are not providing that evidence to the landlord when requested to show how they've been impacted? What might that, maybe it's too far in the future, but once the moratorium is lifted, what might the impact be if they have refused to comply with the terms of the moratorium?
Well, it sounds like in that case, a tenant would really risk legal action taken by by their landlord. Now, the city has in place eviction protections, and we have additional legal services available to tenants. And so we would, certainly encourage, if a property owner knows that a tenant hasn't complied and they're not paying rent, the property owner could certainly reach out to us or to interact with their tenant. We really do encourage communication and communication between landlords and tenants. Ultimately, we're all in this together, and we'd like to find good resolution to helping people remain in their housing, helping landlords maintain their buildings, and hopefully providing a good solution as the economy returns. So a landlord cannot provide a 3-day notice or enter into an unlawful detainer action at this time. At one point in the future, that could be possible if a tenant has not complied with the ordinance. And so we do really encourage tenants, please reach out to us if you're unsure at the information lines, 323-848-6450 and rsh@weho.org. And if you're a property owner and you have questions, or if you feel that you have questions of whether your tenants have complied or not, please reach out to us as well. We're happy to help and assist, and we're here to figure this out together as a community.
Thank you. And this is wonderful information on the website, but I just want to read what you're saying, that the city is here to assist tenants and landlords. So it's a scary process. It's a scary time for a lot of people, but our staff is here and waiting to help out. So don't hesitate to reach out to City Hall, again, at 323-848-6450 with any questions to help you comply. Commissioners, any further questions for Mr. Noonan at this point? I'm trying to have a full screen here. Yes, Commissioner Martz.
Just a comment. I want to commend staff for putting this together. It's very helpful, and there's so many moving parts and moving pieces. And I know a lot of our community members have reached out to me to ask questions, and being able to push them to a website like this with all the information is very helpful. So thank you.
Further questions? Thank you, Mr. Noonan.
So Chair, if I could just add one more piece of information. I do want folks to be aware that the city does have rental assistance programs available for people that are experiencing financial impacts. They are available on our website right at the top of the renter resources page. And to date, since March 16th, the city has received, and city's providers have received over 1,000 requests for assistance, and over 800 of those requests have been approved for a total of nearly $700,000 in rental assistance.
I did hear at City Council recently, they asked why some of the requests hadn't been processed. Something quite simple. They come from residents of the city of Los Angeles, which we can't help with, or some people have asked for the payment to go directly to the tenant and not the landlord. So that explains some. They also said some are just in process. So expect more to catch up. Commissioner Kirby?
Yeah, I have a question. So we're hearing a lot in the news about the governor's eviction moratorium or the judicial council and their eviction processing moratorium, or even the federal government. Do our residents need to worry about that?
We're aligning our eviction protections with the state programs, and it looks like legal counsel's coming on. Allison, would you like to add?
Yeah, so the short answer is no, because our eviction moratorium is going to continue. I think it's important for people to realize, though, that the judicial council order is essentially means they're not issuing summonses. It doesn't prevent a landlord from filing an unlawful detainer complaint. So tenants need to be very careful that they're following the prescriptions in the moratorium so that they're not risking, as Manager Noonan mentioned, so that they're not risking legal action. The longer answer, Commissioner Kirpies, is that they do need to worry about it to the extent that when the judicial council order, when that rule 1, when they lift that and allow the courts to begin issuing summonses again, if there are any unlawful detainers sort of waiting in the queue, in the hopper, then those will be scheduled. And tenants, obviously, as soon as they get anything like a 3-day notice or an unlawful detainer, they can reach out to BETSEDIC and utilize those legal services. But our local moratorium will remain in effect until September 30th as of now.
Thank you.
Just a quick reminder that while we're not speaking, if we can all keep ourselves muted. I know Vice Chair, there we go. We're all muted this time. So with that, we'll go on to our first appeal of the evening, which is 1308 Havenhurst Drive, D-4501. The appeal was filed by both Phillip Roth and Jason Katz. Can we try and bring people in?
Yes, I'll bring them in now.
Thank you. I see Mr. Roth, the little phone symbol. Is that Mr. Katz?
Yes.
Mr. Katz, can you hear us?
Hello.
Okay. And Mr. Roth, can you hear us as well? Mr. Roth, unmute yourself just to say that yes, you can hear us. Mr. Roth? Mr. Roth, if you can hear us, unmute just briefly and acknowledge.
Yes, I can hear you. Can you hear me?
Yes, we can hear you. Thank you.
I wasn't able to hear Mr. Katz.
Mr. Katz, can you say present?
Present.
Okay. Yes, thank you.
Okay. So I'll just explain the procedure a bit. We've been down this road before. Our staff attorney, Ms. Regan, is going to make a presentation to the commission. At that point, the commission will have the opportunity to ask questions of Ms. Regan. At that point, we'll go into hearing from both Mr. Roth and Mr. Katz. My understanding is Mr. Roth might have filed slightly before Mr. Katz, so he will go first. Ms. Regan, is that correct? Both parties are appealing. So you will each have a total of 5 minutes to speak. And if you want to speak for a portion of the time and then reserve a time for rebuttal, we'll just ask you that question before you begin speaking. I want to just stress to both parties that we are an appellate body. We can only review information that is currently in the record. So if you attempt to bring in something that is not on the record, either myself or Ms. Regan will interrupt you, as we can't consider any new information. And with that, Ms. Regan.
I'm sorry, I had a notification come up and I couldn't find my, it wouldn't let me unmute. Thank you, commissioners. Good evening. This is a rehearing from our July 9th meeting, but I will go ahead and summarize the issues for you and for the viewing public. The tenant has filed an appeal after receiving a rent reduction, a partial rent reduction for the kitchen linoleum floor, and appealing the denial of a rent reduction for the resident manager. The landlord has appealed on the grounds that he was not notified about the hearing. Staff is recommending that the commission grant the tenant's appeal. Both parties acknowledged at the hearing that there was not a resident manager living on the premises, and unfortunately, I think the hearing examiner just misunderstood that testimony. And on the issue of the kitchen linoleum, from the decision, it appears that the hearing examiner applied an incorrect standard. The standard is comparable quality. The hearing examiner applied a standard of whether the amenity has been upgraded or is being sufficiently renovated. As far as the landlord's appeal, the landlord was able to attend the hearing and present evidence on all of the issues, and so the obligation to provide the landlord a notice and opportunity to be heard has been satisfied. Thank you.
Commissioners, do you have any questions for Ms. Regan? No questions at this time. So Mr. Roth, if you'd like to unmute yourself, you'll go first. If you can just state your name and city of record, and then let us know how you'd like to divide up your time.
Hi, my name is Phillip Roth, and I live in West Hollywood. I support the findings of.
Sir, how would you like to? You have 5 minutes.
Oh, sorry. I'll use all 5 minutes for rebuttal if necessary.
So that's the.
I support the commission's the staff's findings, so I don't need to add anything to it.
Okay. Mr. Katz, can you unmute yourself? Mr. Katz, if you can unmute yourself.
Hello.
Yes, we can hear you. Begin just by stating your name and city of residence, and then let us know how you want
Jason
to.
Katz. Jason Katz, Los Angeles, and I would like to reserve whatever leftover time for rebuttal. To make it short, I think the old adage of that you get punished for trying would be the case over here. So the staff report references the fact that I came, but obviously I was on a truncated time frame. If we take one look at the calendar of when, as I said, I got the notice late because it wasn't sent to me, wasn't sent to my offices, and we had to receive it secondhand. I received it over the Hanukkah holiday, and then of course the Christmas holiday was in between. The date of the hearing was December 30th. So although I moved stuff around, and honestly I was supposed to be away that week, I ended up moving stuff around the order to make it to the meeting. But my ability to properly present, yes, I presented, and again I gave it the good old college try. But my ability to present and everything else that all the normal rights that I would be afforded were somewhat compressed and limited due to the fact that I got late notice of this of this hearing and all that. And in fact, just as a aside, but I don't want to, the fact that Mr. Roth appealed, I wasn't let known about that. And the first I heard of that was by the July 9th hearing. So again, I mean, I'm not getting proper notices and everything. And so especially when it comes to the hearing on December 30th, I feel like I'm being penalized by trying. And it wasn't, you know, I wasn't afforded the equal opportunity that everybody else was in this hearing to gather and present evidence. So yes, I did show up, but it definitely wasn't on the same level that I could have, should have, and would have. That's with regards to that. With regards to flooring, I do believe we provided a acceptable flooring under most cases. Mr. Roth has expressed that he wanted something different and something more, but I do think that we did use a quality vendor, licensed contractor who provided a floor, which they provided for many, many units. So that's just to that. And I reserve the rest of my time.
Okay. Mr. Roth, you have time for rebuttal.
Hi, would add in rebuttal that as I testified at the hearing on December 30th, I met on October 28th with George Preciado, who was Mr. Katz's employee, and Mr. Preciado on October 28th acknowledged that he had received the list of items to be repaired and was aware that a hearing was pending. So I don't think it's true that Mr. Katz did not have adequate notice. And he also, as I understand it, he himself or his company filed the notice that the building had changed ownership late, and that may have been part of why other notice was not received in time. Thank you. That's all.
Mr. Katz, you have time left for rebuttal.
So just to clarify, what was discussed with Mr. Roth, with Mr. Preciado, was a list that was provided. Wasn't part of the appeal. It was given over to us by the previous management company that Mr. Roth had some issues. So although the list was referenced, but it wasn't the exact list and didn't come in the same form of a proper appeal and of a proper hearing notice. So it's not exactly the way that Mr. Roth is characterizing, although there was a conversation on October 28th. Whatever, I don't know the exact date, but assuming around then.
Is that your conclusion, sir? Mr. Katz, is that your conclusion?
If I need to rebut, but yeah, I'm reserving the rest of the time for that.
So with that, I'll ask my commissioners if you have questions for either of the parties. No questions? And we will go into commission deliberations. Commissioner Kerpes, would you like to begin?
No, I think that I'll be voting to support the staff recommendation. Yeah, I don't see an issue with the landlord not being able to prepare for the hearing. He may not have had a lot of time to prepare for it, but according to the hearing examiner, he showed up, he presented evidence and didn't claim to have evidence that he wasn't able to bring to the hearing with him. And I haven't heard anything like that in the appeal. So I'm ready to support the hearing examiner, or I'm sorry, ready to support the staff recommendation.
Commissioner Maggio?
Can you hear me?
Yes, we can.
Yeah, okay, thank you. Well, just to review it quickly here, certainly the kitchen floor is not comparable and it is thinner, and certainly that has to be changed, and the $19 valuation guideline there for the floor. In regard to the residential manager, there really hasn't been one, even though they say earlier on some of the work was delegated. That really isn't good enough. So I think we have to also allow a evaluation there of, I believe, $30. And in regard to attorney fees, that's not in our purview. That is something that would have to be taken to the courts. And so we have no responsibility there. That's all I have to say.
Commissioner Martz?
I concur with my fellow commissioners on the due process issue. The parties just need to be given the opportunity to be heard. They have to have the government follow a fair process that it treats everyone equally. I don't see any concerns with that here. I also note that the staff report explains that there were some delays on the notification from the new owners, which I think contributed to the issue in terms of the owner getting notification. So I think that was partially at fault of the new owners on the landlord side. And Mr. Maggio is correct on the flooring issue. So I would support the staff's recommendation here.
Commissioner O'Keefe?
I would also support the staff recommendation. At no time did Mr. Katz request a continuance or otherwise claim that he was unprepared or unable to present evidence according to the staff report. It's undisputed that there was no resident manager on site. I believe the hearing examiner awarded the same $19 for the floor, but just asked that it be repaired instead of replaced, given that it was damaged so quickly and was not of a comparable quality as was uncontested. It was thinner. There was substantial evidence to support that it was not of comparable quality, so it should be instead replaced instead of just being repaired. And I think those are all of, oh yeah, and as was mentioned, we don't have the authority to grant attorney's fees.
Vice Chair Topchin?
Thank you. Well, I agree with staff's recommendation in regards to the landlord's appeal. I believe that the due process been followed, and the landlord's representative's testimony at the hearing confirmed that they received the notification a week and a half before, which is about 10 days before the hearing, as the staff report states. So there was adequate time provided to prepare for the hearing. In regards to the kitchen floor, I also agree with the staff's recommendation, as well as the other items, the resident manager. There's no resident manager on site. I agree with that. And also the recommendation regarding the attorney fees. So I concur with staff's recommendation on all these issues. Thank you.
I'm going to agree with my fellow commissioners, nothing further to add. So with that, we have a draft resolution, I believe it's 20-573. Would somebody like to make a motion?
Yes,
Mr. Maggio?
I'll make a motion to adopt the resolution of the Rent Stabilization Commission of 20-572, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and reversing in part the hearing examiner's decision in D-4501.
You have a second?
Second. Go ahead, Commissioner O'Keefe.
Mr. Secretary, can we have a roll call vote, please?
Commissioner Cherry, absent. Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Topchin,
Aye.
Chair Bergstein.
Aye. Motion passes. Normally to both parties, I would direct you to the table where our staff is sitting with further questions, but since we're in virtual land, if you have any questions about this, you can call the city at 323-848-6450 or email your questions to rsh@weho.org. And I believe while you are both welcome to remain for the remainder of the meeting, we're going to take you out of the meeting room, and you would need to log in on the regular Zoom channel. Am I correct in that, Mr. Noonan?
That is correct. At this time, both parties will be taken out of the meeting and they would be able to listen in on Zoom. We also have this being broadcast on YouTube and the city's TV channel.
Thank you. With that, we will go to our second appeal of the evening, which is D-4155 CD4 and D-4428 CD2, 969 North Larrabee Street, Unit 13. The appeal was filed by Ramika Dombrowski and Philippe Osario. Are they present this evening?
Yes.
Appeal of the evening.
Not quite ready for you yet, ma'am. Give us 1 minute, please. Who is Brian Schulli? Is that a representative for the landlord?
Are they present?
That
this
is
evening?
correct.
Okay.
Yes.
Is Mr. Osario present?
Not present, but we do have Romika Dombrowski. I've asked her to unmute herself.
Okay. Mr. Dombrowski, can you hear us? You need to unmute yourself. You need to unmute for a second. Just let us know you can hear us.
Okay. Yes, I can hear you.
Thank you. Mr. Schulli, if you can unmute and just acknowledge that you can hear us. Mr. Schulli, if you could just unmute for a second, acknowledge you can hear us.
Oh, yeah, I had already done
Osario
that. Yes, sir.
present?
Great, okay.
No problem.
So we're going to start the appeal. What will happen is our staff attorney is going to make a presentation to the commission. The commissioners will have the opportunity to ask questions of legal staff. When that is finished, Ms. Dombrowski, you filed the appeal. You will begin, followed by Mr. Henry, the landlord's representative, sorry, Mr. Schulli. You will each have 5 minutes total. As the appealing party, Ms. Dombrowski, if you want to split your time up between initial comments and then rebuttal, just let us know how you want to split up your time. And with
So
that,
is it the appeal for the exterior paint or for the heater?
just a few minutes. We're going to have staff report first. Yep.
This is the heater.
Yep.
Okay.
Okay. Ms. Regan, go ahead.
Thank you. This is an appeal from a compliance determination in case 4155 on the wall heater. The hearing examiner agreed that the landlord had complied with the order to fix the heater so that it heats the living room. And the tenant has appealed from that decision. She is claiming, she's not claiming that it doesn't heat the living room, but she's claiming that now there are other issues that have arisen with the heater. Staff has recommended that the commission affirm the hearing examiner's decision because there's substantial evidence supporting the decision to restore the rent on this issue. Thank you.
Commissioners, do you have any questions? Vice Chair Topchin?
Thank you, Chair. Ms. Regan, so as I understood correctly, those new issues, those additional issues regarding the same heater that were included in the appeal application, obviously we're not going to make any decision on them. We're not going to hear those issues. However, the tenant may file a new rent decrease application based on these concerns?
Yes, that's correct.
Okay. In that case, since there is a 6-month waiting period, I believe, to refile for the same issue. So the question would be before the commissioner if we may recommend to remove that bar, the 6-month bar waiting period. Is that correct?
That's an option for the commission, yes.
All right. Thank you. Thank you for clarification.
Commissioner O'Keefe?
Yeah, it looks like in our packet, we don't have the actual original hearing examiner's decision, but we have a couple of excerpts from it that Ms. Reagan prepared. It says in it that the tenants are entitled to a rent decrease based on a heater that does not direct airflow into a living room, and that the landlord's entitled to have it restored once they've restored the housing service. Ms. Regan, is it, since we don't have the original language, but you've reviewed it, is all of the language about what the order was specific to directing the heat to the living room, not framed in a broader way about returning functionality to a heater?
Correct. And I believe, yeah, that's correct. And I'll try to find that in the packet.
Good. And apologies that I didn't request it earlier.
Commissioners, any further questions? Okay, Ms. Dombrowski, if you would unmute yourself.
Yes.
So, to begin, you'll state your name and city of record. Let us know how you want to divide up your time. You have a total of 5 minutes. You can split it. I do want to caution you, we are an appellate body. We can only discuss what is currently in the record. So other issues that you wanted to raise are not on the record, are not subject of tonight's hearing. And if you try and bring in new issues not in the record, either myself or Ms. Regan will just have to interrupt your testimony. So you can only speak on what is in the record tonight pertaining to the heater. So go ahead and state your name, city of record. Let me know how you want to split up your time.
Okay, so my name is Romita Dombrowski, and I'm going to split up my time half and half, so I have the chance to rebuttal.
Go ahead and start, ma'am.
Okay, so as I moved in 2013, the landlord Susie Montgomery, the previous landlord, provided a furnace what was placed inside the wall and vented to the hallway, to the bedroom room, and through another air grill directly to the living room. Mrs. Montgomery downgraded the heater to a wall heater, what only vented to the bedroom hallway. So the new landlord redesigned the heater and moved it to the living room and put another outlet to the hallway. So it's supposed to vent the bedroom hallway, but no air ever came out of the air grill. And the new heater is just more bulky than the furnace was before, and it's not placed inside the walls. And the wall where the original heater is still cracked. The new heater doesn't have the tiles underneath, what prevent code compliance ordered that because there might come sparks out of it or flames, and I have carpet, so they ordered that there will be tiles underneath. There are no tiles placed on the heater, what's going to the living room. And also the new heater was not venting correctly into the living room until the end of May. So as the landlord filed for a compliance determination request, the heater did not work correctly and exploded constantly, made loud banging noises. There were flames coming out of it until the heater did not work at all anymore. And then in the end of May, a worker came over to fix this issue. Yeah. But it's still not venting in the hallway where it used to vent.
Thank you. Mr. Schulli, unmute yourself.
Yes, sir. Thank you.
State your name, city of record, and you have 5 minutes total. You do not have rebuttal time.
All right. Thank you, sir. My name is Brian Schulli. I am the resident manager here at 969 Larrabee, and I'll be representing Laura Way Holding, which is the landlord's LLC for the building. So to the point of the claims that were made as far as the air not blowing out of the back of the heater, I think it's important to point out that the furnace is a gravity wall furnace. There is no forced air. So it's just, it carries up with gravity. There would be no air coming out of the front side either. To the second point, I was a little taken by surprise by the explosions of flames coming out of the front of the furnace, which Ms. Dombrowski just reported, because that's the first I've heard of that. As far as the explosions, as she called them, were concerned, that is the sound of metal as it expands and contracts as the heater gets hot and cold. That is what she was talking about. That is just part of the furnace. There's nothing I can do about it. As it heats up, it makes popping and banging noises as it expands. As far as the secondary outlet that is coming out of the back of the furnace, that was built to the specifications of the manufacturer for an alternative outlet. It's actually a knockout panel in the back of the furnace, which we attached a exterior vent to go out the backside and come through the wall. And that was all introduced during the hearing as well, along with pictures to show how the design worked and everything from the manufacturer. As far as the moratorium being lifted for the 6-month restriction, I would ask that that
would be an outside issue, sir. We would not be considering that during the appeal.
Oh, okay. I'm sorry. It was brought up, so I thought it was relevant. And I would just point out that the other two minor problems that Ms. Dombrowski reported as being problems that caused the furnace to not work through May, as she said. There were two instances of a wire that was brittle. One was repaired immediately upon the first report. The second one, there was a delay at the tenant's request to stay out due to COVID, unless we had somebody with specific gear due to health concerns on their part. And we did bring somebody in and they discovered that there was a fragile wire within the thermostat, which was also repaired. Both of those were unrelated to the complaint of the furnace not venting. And I think that's probably it for me.
Okay, thank you, sir.
Thank you.
Mr. Secretary, how much time does Ms. Dombrowski have for rebuttal?
That's 3 minutes and 12 seconds.
Okay, Ms. Dombrowski, your rebuttal. Need to unmute yourself, ma'am. There you go.
Yeah, so the issue is basically that the original heater was inside the wall and vented perfectly into both directions, and this new self-designed heater was not working correctly as the landlord filed the request for compliance determination. And yeah, it wasn't fixed until May, and that was months later. Yeah, and that's all what I have to say to that. And the heater just didn't work.
Concluding your remarks, ma'am?
Oh, what do I have to say?
Is that concluding your remarks? Are you finished?
Yes.
Okay,
Yes, I'm finished.
So commissioners, do you have questions for either of the parties? No questions, and we'll go into commission deliberations. Commissioner Kerpes, would you like to begin?
Actually, I have a question maybe for Staff Attorney Regan about I'm just looking here through the document. I thought I was satisfied with what I had read prior to the meeting, but now that I'm looking for it, I can't find it, and I don't actually remember if I read it. But as to Commissioner O'Keefe's question about the original determination by the hearing examiner early on, do we have that in the record somewhere?
Yes, so I found it. It's on page 82 of your packet. And this is, remember, this was an earlier compliance, so there have been a couple of attempts to restore this rent. And so an earlier compliance determination, it was denied because the heater was not directing heat into the living room. So if you look at page 82, and it goes into 83, it prevents heat from flowing directly into the living room. The landlord did not specifically state that the heater now directs airflow into the living room. The request for compliance is denied. So it's this decision that the landlord is now claiming compliance with, and that it's this that the current decision is trying to decide if there's now compliance, and the decision decided that there was, because it directs heat into the living room at this point. I know it's very convoluted.
No, I think I understand. If we could go on to the next commissioner, maybe, and I'll read this while others are commenting. Chair. Thank you.
Commissioner Maggio?
Well, I'm not entirely satisfied. I think there has been compliance on a certain level because of the directing the heat into those areas that need it. I'm a little concerned still about the safety of this heater. I know it's really difficult to replace heaters in old buildings where maybe an old heater was and you can't repair it. But I think at this turning point, there is a compliance, so I'm going to support the hearing examiner's decision.
Commissioner Martz?
I would concur with that assessment. Our job is, again, to look if there was any substantial errors made by the hearing examiner. I don't see anything in the record that would show me that his or her determination was incorrect. He's the one with the facts And we are just looking at the overall record, and I can't find anything to say that his decision was incorrect. So I would support the staff recommendation.
Commissioner O'Keefe?
I still, what we see on page 82, I think it was, is the compliance determination. I would really like to know what the actual original hearing examiner order required the landlord to do, because how it's worded seems very important. If the order was to make the heater function be restored, then that would be very different than if it solely was about venting into the hallway. But it doesn't look like we have that in the record. We do have in the record the staff attorney said, you know, in one phrase that it did. It sounds like, Ms. Regan, you haven't found the actual original hearing examiner order in that case. The original decision.
For me?
Yeah.
Because that, yeah, because that's not what's being appealed from. The compliance determination was specifically, the reason why it wasn't restored in the first place was because the heater did not direct heat into the living room. And so in order to get the rent restored at this point, for this next compliance determination that is being appealed, the operative order is from that original compliance determination, if you know what I mean.
So if the original order said, fix the heater, make it work again, and then they went and asked for compliance, and the tenant said, it doesn't work because it doesn't go into my living room, that compliance determination could be rejected because it didn't go into the living room. But that wouldn't mean, because it later goes in the living room, that they complied with the original order, which could have been fix the heat generally. So what I'm wondering is how that original order was worded, because if it was worded broadly, then I would have a different conclusion than if it was worded narrowly, to just be about going into the living room. If the original order was fix it entirely, the fact that at one point they didn't have compliance for a different reason doesn't seem to bear on have they completely complied with it or not. So I just would feel a lot better if I knew what the original order was, so I could know, has it at the point of the most recent compliance determination, was it at that time in compliance?
So, on page 82 that I referenced, the hearing examiner talks about what the order requires. In, I don't know, 1, 2, 3, 4, the 5th paragraph, the order requires the landlord to repair or replace the wall heater. And then it goes into the tenants are entitled to a rent decrease based on a heater that does not direct airflow into the living room. So there's a quote from the original order. So that's what the compliance determination is based on. Does that make sense?
I hear what you're saying, but I still, you know, without, like, the resolutions that we pass have very specific language of how you fix it or not, and how the original resolution was worded, to me, would be determinative on how I would vote. So struggling with it here, but let's move on to the next commissioner, I guess. Deliberations.
Vice Chair Topchin? Unmute yourself. There you go.
Thank you, Chair. Well, I see the point, and I agree with Commissioner O'Keefe and Commissioner Purpose says concerned about the original order from the examiner, but given the language of the compliance determination that Ms. Regan just referred, everything seems to me references the living room, the heat provided to the living room, according to what I see here. Of course, I would love to see the heater fully functioning and providing the heat to the living room and both to the bedroom and the hallway. That's no question about it. But what I see here, everything I read, it's everything it talks about the providing the heat to the living room, and the specific order for this hearing. The order was to, I mean, it had to be determined whether the heat is provided to the living room, and the examiner found that the owner complied with that order. So But again, since the tenant's appeal application specifies other issues, including that it's not providing the heat to the hallway and the bedroom, and bathroom and the bedroom and the hallway. So that is my concern, of course. And we see the time goes by so fast. We're in mid-August, maybe in October, the tenant would need probably the heater fully functioning. So if we would agree that the owner complied with this order and restored the heat that is provided to the living room, then I will definitely urge the commissioners to, whoever is going to make that motion, to remove that 6 month waiting period for the tenant to file a new application, a rent decrease application, so that the due process can start and the other issues can be resolved. So that's how I see it. If you know, unless we find the original order that specifically says, as Commissioner O'Keefe said, fix the heater, make it work, which means provide the heat, you know, everywhere, including the bathroom, the hallway, and the bedroom, etc. So, but if we don't have that, so I'm actually fine with the current recommendation to affirm the hearing examiner's decision. Thank you.
Mr. Kerpes, did you want to add?
I have a question again about kind of the process that Commissioner Topchian just spoke of for Ms. Regan. If a determination was made this evening that, if we made the determination this evening that it was the restore the rent because they have complied with the repair, the maintenance, then wouldn't that work against the tenant if she were to make a claim that when I moved in to the apartment, the heater did this, and it's not doing that now, because now there's something on record that we've said, no, this has been discussed, and we've said that they've been maintained the maintenance, or could it be a separate issue and she wouldn't be at a disadvantage by our decision to affirm?
Yeah, it could be a separate issue, particularly since this is an appliance, and so this is dealt with under the maintenance section, not under the substantial compliance section. And as I say, the original order only talked about airflow into the living room, so none of these other issues that she's raised have been discussed.
That's my other question, is so it references where it cites the original discussion. It cites decision page 7. Do we have that?
Well, it's quoted. It's not paraphrased. That's the exact quote from the decision. So that's what the order was.
But we don't have the decision.
It's not in your packet. I mean, I'm happy to, if you don't believe me, if you believe that
who drafted this. I don't even know who drafted this.
I mean, it's quoted there. I can give you a 1,000-page packet every time if you'd like. I mean, I didn't think
I think this comes to the heart of the issue.
But it's quoted. It's quoted directly. It's not. There's no question that that's the order. So I'm a little confused as to what I mean.
I'm leaning towards that this is probably accurate, but I shouldn't just go off of because somebody put a little citation at the bottom. Like, I should be able to see the citation, right?
Sure, absolutely. I'm gonna try to find that for you if this is gonna make a difference.
The reason behind that, just while you're looking at it, I won't ask any more questions. I'll just kind of talk. The reason behind that is exactly, I think, what Commissioner O'Keefe said is, if I have a very similar heater, but I'm just going to use it as an example. If I say that my heater's not, my old heater blew out both sides and it kept my bedroom warm and my living room warm, and then they put in a new heater and I say it doesn't work, and they said, well, why doesn't it work? Just exactly like what Commissioner O'Keefe had already explained, that if I'm complaining at that point about it not shooting out air into the front living room, just because I avoid the conversation about the bedroom, that's not the issue. The issue in front of the hearing examiner right then, and so they deny it and base it on because it didn't blow into the living room. that doesn't address the fact that a new heater that only blows into the living room isn't now going to fix my bed, heat my bedroom. I'm leaning towards that this is probably all legit, but I shouldn't just base it upon a reference that I can't see. That's what I have.
Okay. I'll see what I can do. I'm gonna have to do some techno mumbo jumbo. So
I guess my last question for you.
If the decision, I mean, I don't know what the deliberations are gonna be, but we may have to do this at the end if necessary.
I was gonna say, or could it, if we can't do it tonight, after you look, could it be remanded back for the hearing examiner to look at?
I'll find it tonight.
Okay.
I will find it.
Commissioner O'Keefe, I see your hand raised.
Yeah, if I may, I just want to mention, it's not that I don't trust the paraphrasing, it's that sometimes there are a lot of different things said in the same decision. And it could be that in one place it uses that word terminology, but if there was any place in the order that uses broader terminology, that would influence my decision. So since Ms. Regan's looking for that, I don't know if it's possible. We have the same parties for our next appeal. I wonder if we could do that appeal and then come back to deliberations on this.
Well, I would recommend, again, I don't know how the vote is going to be, but have we heard from everyone at this point? We haven't heard from Chair Bergstein, so I'm going to leave it up to the chair at this point.
So first, I just want to point out to Commissioner O'Keefe, it wasn't a paraphrase from my understanding from Ms. Regan. It's a direct quote from the record. So it wasn't, it sounds like this, sounds like that.
Yes.
I don't have the issue that a few of my commissioners have. To me, this is very straightforward, where a housing service was no longer functioning. It was replaced. As it was originally replaced, it wasn't functioning as the old one did. There was a compliance termination where they took out that panel, I forget what they called it. So the airflow has been restored to both sides. So I don't have an issue with this. I do want to address Vice Chair Topchin's comments about waiving the 6-month rule, refiling. If it was, I'm not in favor of that if it's for any of the outside issues that the tenant attempted to raise during this appeal that we could not hear. I think that if those are the issues she has concerns over, she needs to go through the regular process, notice her landlord, ask to have the repairs, wait 30 days, contact city staff. It shouldn't just jump ahead because it was mentioned during an appeal when we can't consider it. So on that one point, I would be opposed to waiving the 6-month rule. So I'm not sure where we are, fellow commissioners. Are we going to wait for Ms. Regan? Are we prepared to make a vote on this? Crickets chirping. Commissioner Kerpes.
If we can't wait, then I would be either motioning that we remand this to the hearing examiner to look specifically at the original order, or I would be voting against the motion. Or I'd be voting against the motion to uphold the hearing examiner at this time.
We want to take maybe a 3-minute break, give Ms. Regan a few minutes to try and locate that and then come back on the record.
So I have it.
Oh, there we go.
I'm waiting for it to load, which may take a while.
I'm in favor of a short 3-minute break. I think that might be best.
Okay.
Once we have it, we might need a 3-minute break to read it too.
You don't want me to just read the order? Okay, no problem. I don't know how I'm going to get it to you. Is the thing. I mean, I was thinking I could share my screen, but if you're going to need to read the whole decision as opposed to just the order itself.
I think the order is enough. You can share your screen with the order as far as I'm concerned.
So then what's that?
I was sorry. I was going to say I'm probably going to be satisfied with the order.
Okay, then I can just also read it to you verbally if you trust me to do that. I'm on my iPad, so I would need to log off and go onto my laptop for Zoom in order to share my screen. So it's up to you all. Do you want to take 3 minutes and then if I can get this to load?
I think that's a good idea.
Okay.
Chair's out, all right?
Forgot I muted myself. Yes, that's a 3-minute break. Thank you.
All right, great.
We're at 8:05, 8:08. We'll come back.
Great.
It's there. Ms. Regan, are you with us? Ms. Regan? May need to go a couple more minutes just so we get Ms. Regan back on the line.
Just out of curiosity, does anyone know what that ding is when it dings like that?
Gotta be somebody's computer or phone is my guess, but I don't know who.
I think it's mine, and I don't know how to turn that off and leave the sound on my computer. I apologize.
Oh yeah, you're the least muted one.
2 computers. I have Raul's on next to me with our agenda on it. That's why I keep going like this. So I think it's one of the 2 might be dinging. My apologies.
Chair Bergstein.
Yes, sir.
While we wait for legal counsel Regan to return, I'd like to share that the Rent Stabilization Commission meeting is currently streaming on WehoTV. That's the city's WehoTV channel. We also have it streaming on Spectrum Channel 10 and smart TV apps. At this time, the meeting is not streaming on YouTube. We do have a message on the YouTube channel that directs people back to weho.org/WehoTV. So folks that would like to view the meeting, participants in the meeting now that would like to view the meeting after can follow along on those channels.
There was an issue in the latest city council meeting where there was a fire and a lot of people's spectrum was cut off. So they didn't have access to internet. And I'm wondering if that ever were to happen here. I think it was recommended that people just call the phone number that they can call in for public comment as a backup. Is that something that can happen for any of these meetings if there's ever an internet outage?
That sounds accurate. I will follow up and confirm.
I will say
there
that
was
there was
Brown
a
Act concern.
telephone pole on my street that caught fire just as a particular item was being presented to council. And it's also, I don't know if anyone else has noticed, if you are on hold waiting to speak at a council meeting and you are watching it on your computer, there is a time lag in between what you're hearing on your computer and what's on your phone. So I learned to turn up the sound off on my computer so I was in the same time zone. I see Ms. Regan, you're back with us.
Yes, I think I figured this out.
Okay.
You got a number of things. I'm very excited. So I'm going to share my screen with you. So before I do that, I'm going to preface this by saying, so what the hearing examiner did in that initial compliance determination, and I'm talking about the one on page 82, she drilled down a little deeper because that first sentence says the order says repair or replace the wall heater. That's all it said. And that there's no dispute that that's what was done. And so what the hearing examiner did then was look behind that order, so let me share this with you so you can see what I'm talking about. So this quote, is this working?
Not yet.
Oh, get out of there. Oh, yes. Oh, I don't know what's happening. Can you see my screen?
No.
If you're seeing a number of options in front of you, you would want to select the one that you want to show. That might be the case.
I have a spinning wheel and I don't know why. Oh, I was so sure this was going to work. Okay, let me see if I can get rid of this dialog box that's kind of in my way here. And not sure what's going on there. Nothing?
No.
Okay, so as I said, the order was to repair or replace the heater, but then, and in that compliance determination, there was no dispute that that was done, but the hearing examiner determined that that was not sufficient because part of the issue with the heater was that it didn't direct heat into the living room. So even though the heater had indeed been replaced, the request to restore the rent was denied because it still did not direct heat into the living room. And I'm just trying to find that language where that is, where the quote came from the, here we go. Okay, she testified that before the heater was replaced, it directed airflow into the living room. Now the heater does not direct airflow into the living room. So that was a focus of the issue. And so even though the order, the full measure of the guidelines evaluation does not apply because the heater is not completely inoperative. It vents air, but not into the living room. So on that, that's where the rent decrease of $60 came from.
Commissioner Kerpes?
And that to me tells me that the heater was working properly, except for the fact it didn't heat the living room.
Correct.
And so what I'm understanding from this heater is that it only heats the living room.
It does heat the living. Oh, okay. I see what you're saying. So let me see if there was any testimony about if it directed heat anywhere else. No, the only, let's see. Oh, I see. So they talked about different so there were other issues with the heater that were repaired. So they talked about a repairman coming up and vacuuming and cleaning the heater and checking it. So it wasn't just that it was not actually working, but now she was saying the airflow. Oh, sorry. The prior heater. Oh, the manager testified that the current appliance is a gravity heater designed to heat a single space in one direction. Oh, so the issue was that it was backwards. It heated in one direction, but it heated the hallway. So the issue was they wanted to flip it around and heat the living room. So it wasn't that it had heated both before. Does that make sense? I'm going to try this one more time.
I think Ms. Dombrowski is trying to speak. I don't think she's allowed to at this stage of the meeting, but you're muted, so you know.
Thank you.
No, and I allow Zoom to share your screen. Yes.
Vice Chair Topson, did you have a comment you wanted to make while she's searching for that?
Yeah, I remember that I think it's on the record, and I remember the tenant's argument. I think the original heater provided heat to both directions. I believe that's what she said. And the heat was provided to the hallway, bathroom, bedroom, and the living room. And then it was replaced by the previous owner or manager. And that's what she got now, is that heat directs to the living room. So I think that the order was about that one, but not the original. If I'm understanding correctly, not about the very original heater. So now under the RSO, again, maybe it's not the issue for a discussion today, for a decision today, but obviously if we're talking about the restoration of the service, restoration of the original service, what was provided before. So that's how I think. So now whether we are, whether our hands are tied to only make a decision about the living room, that's different. Now we have something on the screen, Ms. Regan.
Did that work?
Yes, we're up.
Look. Okay, so I'm gonna just make this a little. Am I in the way? Is anything in the way of this? Okay, so I'm just gonna scroll back to the beginning of this discussion. So see wall heater and let you all read that. Do I need to get anything out of the way, or can you see everything?
If I minimize our cameras, can I bring it back? Because it's blocking part of my screen.
Let me see if I can get rid of it. How's that?
No, you can minimize it, Chair.
Okay. Yeah, thank you.
Tell me when to scroll down.
Scroll down, I think. Scroll further.
So this is the quoted language here. The tenants are entitled to a rent decrease based on a heater that does not direct airflow into the living room. Oh, sorry.
But that's been, from my understanding, that has been taken care of. They removed, I forget the term, there was some kind of a plate on one side that now faces that living room, so the air is, gravity fed heating both areas. Am I correct?
That's what you're trying to decide, whether there's substantial evidence that supports the hearing examiner's decision that to restore the rent based on the fact that the heater now does direct heat into the living room.
And this is the entirety of the decision.
This is the yes, this is a discussion on, this is the entirety of the discussion on the wall here. Yeah.
I have deliberation whenever you're ready for me.
Okay, I have lost all of our faces. How do I bring Commissioner Kerpes?
Hit that camera, little blue camera.
I'm gonna stop. Can I stop sharing?
Yes.
Yeah.
I don't have a blue camera. Oh, there we are. Thank you. Whoever did that, thank you.
I think I needed to do
Okay.
that. So
Thank
I'm
you.
gonna let you all deliberate. I'm gonna take myself out now.
Okay. Thank you. So we begin deliberations. Commissioner Kerpes, would you like to begin?
So I think that this is difficult in that I think it's just natural to assume that the heater that worked properly, that was no complaints, heated the apartment in an ample manner, and that through the process of changing heaters, heat was not directed. It was intensely directed into the hallway and not directed into the living room. And the complaint today is that she doesn't feel it's in compliance, not because it doesn't throw heat into the living room, but because it no longer heats the rest of her apartment. But I don't think, and that's where I would go with this, because I'm just basing it upon natural, what I think that is reasonable for somebody to argue. But I think that we should remand this back for the hearing examiner to have a full discussion about this, to allow both sides to testify at that time what was in the original unit when she moved in. Because I don't think that an argument that it fully effectively heated the rest of the apartment and didn't blow into the living room, that argument, or the argument that it didn't blow into the living room, and that's what I really wanted. I don't think either one of those conflict with each other in terms of preventing or having new evidence from the original argument. I think that the first hearing examiner in the decision, it was so broad that they could both reasonably make those arguments, or she could make either one of those arguments and it wouldn't be new testimony. It would be all reasonable based upon that original argument. And I don't think that she was allowed to do that based upon the narrow scope of what this newer version or this newer interpretation or the specific focus of the original decision that got transferred over is. I think it's perfectly reasonable for someone to leave out all arguments about not the parts that it worked properly on. We're only focused, we're naturally going to focus on the things that aren't working, even if everything else is. And so that's my fear, is that she moved into an apartment that the heat was regulated just fine. She was happy with that. And then she's had several problems with several heaters. I think there's been at least 3 heaters replaced. And through all of that, it's got narrowed down to now she's in this corner where she's only allowed to heat her living room or bypass the rent reduction. That's my concern. And I think that a hearing examiner would much better be able to explore this and flesh this out than we would be able to, because we don't have any evidence to do it with. Thank you.
Commissioner Maggio?
Well, of course, I'm concerned with safety primarily. Is it safe? However, I think there has been a correction, because the heat is now directed in those two directions, which has been done and asked for. Whether it's doing it efficiently, that I can't answer. So I'm a little kind of changing my mind and thinking maybe this heater is not correct, and maybe we have to look at it again, or the hearing examiner has to look at it again.
Commissioner Martz?
It seems to me we have, in my opinion, a chicken and the egg situation here. We have heat directed at the hallway versus heat directed at the living room. And if it can only go in one direction, and the order was to direct it to the living room, and that's what was done, and that's what the hearing examiner found, that seems technically to be in compliance with the order. But now the tenant is left without the heat to the hallway. So it just seems to go back and forth. So this has been around for a long time. I hate remanding things because the process is slow and it doesn't give speedy resolution to problems for both the landlord and the tenant. But I think Commissioner Kirby's solution is probably the best solution for a difficult situation, because it's just kind of a mess. And I think Mr. Kirby's is correct that you don't always bring up the good, you only discuss the bad. So I think remanding it to create a better record is probably the most appropriate decision here.
Can I share my screen once more to show just some of the evidence from that original hearing, which might help, because there was testimony which the hearing examiner seemed to accept, that the current heater was unidirectional and that it was installed backwards.
Yes.
And so that's what the order was designed to correct.
Yes.
Sorry. Can you see my cursor?
Yes.
Yes.
The current heater is unidirectional. It needs to be turned around. And so that's what the hearing examiner was looking at, that it's supposed to direct airflow into the living room, and now it doesn't. Because so.
Did you put the actual order too? The order language about the heater?
Down at the bottom?
Yes, please.
Yeah, as I say, it just says repair or replace the heater.
Oh, okay.
It doesn't specify.
If that's all it says, then I don't need to see it. It's really just that simple.
Let's just, where is
Chair, I have a question when you have a chance.
And take all acts reasonably necessary to perform this maintenance. Okay.
Right, that's in all of them.
So Ms. Regan, the question. So it looks like this says repair or replace in order for the heat to be pushed out into the living room. And then the compliance determination made a determination that that had been done in terms of directing the airflow heat to the living room.
Correct.
And that is what the appeal is based on today.
That's correct. And what Commissioner Topshin had mentioned is that if now there are different problems with the heater, those can be addressed
separately.
Correct.
Okay, then based on that and the original order, I would go with the staff recommendation, because that's what's been done. And the hearing examiner made the compliance determination. I don't think there was any error in that determination based on the record. And as Vice Chair said, these can be brought up in a separate process, but not through this one. So I would go with the staff recommendation.
Commissioner O'Keefe?
I I would remand it. One note for Commissioner Maggio, you mentioned that it's going in both directions now. I'm not sure if that's the case or not, but we have to make a determination based on the facts at the time of the compliance hearing. And at that time, Ms. Dombrowski said that it was not, and I'm not sure if that it was only directing into the living room. So as I see it, the initial complaint was that there had been a substantial reduction of a housing service, which was that at one time there was a heater that functioned well and heated the entirety of the unit, as far as I can tell. This was then replaced by a different kind of heater that only heated part of the unit, and it was directed only to the living room. At that time, what she asked for was it to be turned around so it would heat the larger area of the living room instead of the hallway. But the core issue of the substantial reduction of the housing service could still be there if it only heats the living room and not the hallway at this point. It's less bad, but it still could be a substantial reduction of a housing service, just in a different way. So for that reason, because it seems like there is still a substantial reduction of a housing service, the original issue was it had seemingly, she'd had a different heater, that this was not set up in this way to purposefully only heat part of the house, that now there still would be a substantial reduction probably, it just might be less because now it heats the living room instead of the hallway. So we aren't the finder of fact, I wouldn't say that for sure, but certainly there seems to be some evidence on the record, and it doesn't seem like that was the analysis that the hearing examiner looked at. The analysis the hearing examiner looked at was, does it now heat the living room? And to me, that's not the original. The original hearing examiner said repair or replace and take all actions necessary. So I would say if it repairs it in a way that remains a substantial reduction, she shouldn't have to file again because it's the same thing. It's a heater that's less than what she originally had. She originally had a heater that heated everything. And she knew it was this heater that could only heat in one direction, and they made it less bad, but not on par with what it was initially. So I would remand it for a determination of if there is a substantial reduction of a housing service still compared to what initially was, for the heater to be repaired and replaced, you know, to be back to made whole from what it was, and if not, what the remaining reduction should be.
Vice Chair Topchin.
Thank you, Chair. So if we go solely based on this compliance determination and the order to restore the airflow to the living room, then we're saying that the landlord complied because the landlord restored the airflow to the living room. So, but as I mentioned at the beginning, so my concern was obviously, what about the other issues? And specifically the issue related to the heat provided to the hallway, bathroom, and the bedroom. I have a similar wall heater here, so I know what the, just like Commissioner Purpose mentioned, when I know what the heater is about, what type of heater we're talking about. So now, but since well, initially I was ready to support the staff's recommendation, because if we are thinking about whether the heat is provided to the living room, yes, it does. However, if we look into the original order and the order to fix that or repair and fix in the way that the heater is going to do the job, is going to work, that would provide the heat to the entire unit, just the way the original heater was functioning, which based on the test argument by the tenant, I believe there was a discussion about that at one point, that the original heater from, I believe, 2013 when she moved in, that provided heat to the entire unit, including the living room and the bedroom and the bathroom and the hallway. So, and I agree with Commissioner O'Keefe's comments. I believe that the question here, whether the owner complied with the original order from the hearing examiner. So, and based on the language of that order as or the discussion that Ms. Regan provided, that it talks about the current heater, but I believe that was from what was the discussion, Ms. Regan? Is that the document that you provided? Is it from 2016 or? I believe 2016, right?
I don't remember the
Okay.
date.
For some reason, I think, again, I may be wrong, but I for some reason I remember 2016. So if that 2016 current heater, the current heater was providing heat to the living room only. So I'm kind of turned, to be honest with you, in between supporting the staff recommendation or remanding to the examiner. I'm leaning more towards remanding back to the examiner to kind of look into that original order and whether there was a compliance and that. Because this one is very narrow, it talks only about the living room, but the issue is bigger based on the original order. The issue is to repair and replace to the point that it's gonna function properly. So I guess I'm leaning towards supporting the commissioner's comments, recommendation to remand to the examiner.
So the issue, as I see it tonight, was the airflow restored to that living room? That was what was in compliance determination, and that airflow has been restored. There was never a question in that hearing about it's not heating up the kitchen or the bathroom or any other area. So I feel that we have no choice but to uphold the hearing examiner's decision because that airflow has been restored pursuant to the order. And then going with what Vice Chair Topchian said, if the tenant would like to bring basically a new action saying, well, the airflow may have been restored to the living room, however, these areas of my home that used to be heated are no longer heated. So it's not been like for like, I would waive the 6-month rule on that. But I don't believe for the decision before us tonight, I would not be in favor of remanding it back to the hearing examiner. I think that we have been presented evidence that what was ordered has been restored. And we're kind of grasping at straws and looking for other areas of the home that are not part of that order. I see a couple of hands going up. Commissioner Kerpes?
I think that the fact that, I don't know if it's a 2-3 or 3-2, but the fact that there are different opinions about what the original document stated is evidence enough that we should send this back because the hearing examiner was not privy to the information that we had. The hearing examiner based their decision on the document, I keep pointing at my computer screen, the document that just has the citation and the compliance determination, the most recent one. So the hearing examiner hasn't had as much information as we've had this evening, and even we're confused, or not confused, but we have different opinions. So I really feel strongly that this should go back to the hearing examiner, be remanded back to the hearing examiner to really look at the entire case and to allow both sides, both the tenant and the landlord, to talk about it. I want to really thank Ms. Dabrowski this evening for sitting there silently, appropriately silently, as we talk about this, because she knows what has occurred over time, and she has probably a lot to say, but she can't in this realm, but she can if we send this back to the hearing examiner. I don't see any harm in sending it back to the hearing examiner for a review of the entire picture.
Vice Chair Topchian, did you have your hand up?
Yeah, since I initially I said that I was supporting the staff's recommendation, but if we waive that 6-month waiting period, and you, Chair, you said that you're not supporting that. So no, I see the kind of the benefit of remanding the case back to the examiner. But I would also be okay to affirm the decision today based on the evidence we have before us tonight. But to waive that 6-month waiting period so the tenant can go back tomorrow to the city and file a new, decrease application and address the original heater issue to make sure that the heater is fully functioning. That also would be fine with me. So now I want to see if the commissioners maybe, will go that direction. So I'm like in between right now. I could support the staff's recommendation, but only with waiving the 6-month period, waiting period. Only that would be the condition if I would support the staff's recommendation. Otherwise, I would just remand it back.
Commissioner Martz?
I would go with the chair and vice chair's recommendation to uphold the staff's recommendation with the waived 6 months.
So unless there's further discussion, we have a draft resolution RSC 20-577.
I think Commissioner O'Keefe wants to add
Further
something.
comment, Commissioner O'Keefe?
I had a question for Ms. Regan. A compliance determination, the purpose of it and what they're deciding is if it complied with the order from the hearing examiner for restoration of rent. Is that right? Or is it sometimes whether they complied with a subsequent compliance determination? Comments?
It's the order, right?
Okay, so for the chair's benefit, I mean, he mentioned grasping at straws and I think was alluding to that we shouldn't be looking at the original order. We should only look at a compliance determination. And I just want to make sure that fellow commissioners heard that and that what we are deciding is if the landlord has complied with the original order.
Is there any further discussion at this point? So it sounds as if we'll start with draft resolution 20-577, and if someone would like to make that perhaps with language that would include a waiver of 6 months, and we'll see how that vote goes. Commissioner Kerpes?
I just want to explain why I will not be voting for that because I think that's a good compromise. I just don't see how a tenant can come back in. I mean, I think that the tenant is at a disadvantage to file after the commission has said that you've been through the hearing process, you had a faulty heater, all the maintenance was done on it, and it's now in compliance. I don't understand how one could make an argument then that same heater is not in compliance or is not a substantial decrease in services from my original tenancy, because that's what I've already done. I've already went in and argued that, and it's been through the course, and it's worked its way down to the narrow issue. And today, the commission might say it meets the order. So why would she be able to retry this entire case all over again? That's my question, kind of. And that's why I wouldn't be supporting it unless maybe one of the lawyers on the commission can explain to me how that's not out of the norm, and that would not put the tenant at a disadvantage, start her off on a disadvantage.
So I still think my understanding is that there was a removal of the housing service from the original furnace years ago that was replaced. And then she said it was done backwards. It wasn't flowing in the living room. The hearing examiner said, restore that, and it was restored. So now separately, issues are being raised that even that with the restoration of that airflow back into the living room, it's not doing the job of that original furnace, which to me is separate and apart from what we're hearing tonight, which is why I'm in favor of upholding the examiner's decision, waiving the 6 months, allowing her to bring up other facts or evidence on how this particular furnace does not fulfill the job that the original furnace did. Commissioner Topshin, I think you had your hand up.
Just to respond to what Commissioner Kerpes said and other commissions maybe. So my concern I'm okay with cases remanded back to the examiners. That's not a problem, and I believe if there is a need for it, we should do it. But my concern is the specific language of that original order that says current heater. I tried to make these notes, but it says, it talks about the current heater. If we're talking about the current heater in 2016, that was not the original heater in 2013. So the landlord may have complied with the order at the time. And my concern, if it goes back to the examiner, and the examiner looks in the order and says, okay, so it talks about the current heater, and the current heater in 2016, the function was only to provide airflow to one direction, because that current heater at the time was not to provide air to both directions. So, and I'm afraid that remanding back is not going to really be helpful, and it's going to just prolong the process, because the examiner will just say, okay, so the current heater was to provide the air to one direction, whether it was backwards or this way now to the living room. It's done, it was resolved. But my concern is that what was originally provided at the time of renting, which was a heater with the airflow to both directions. So that's why I was thinking, if that we waive that 6-month waiting period, the tenant can file a new rent decrease application based on specifically on that original housing service that she doesn't have it today. And she didn't have it the very first time, when the first time the heater was replaced, whatever the year was. So when she moved in, she had the heater providing airflow to both directions. Then with the request to replace the heater, the very first heater only provided heat to one direction. So from that time, she didn't have the heat to the both directions. So I think that's a totally different matter. And I don't believe, that's why I'm thinking now, if we remand it back, so the examiner, it's not going to be really helpful. The examiner is going to look specifically to that order from 2016, if I'm not mistaken. It got stuck in my head, 2016. And at the time, the current heater was the heater that provides heat to one direction. So that's why I think the benefit of waiving the 6-month period is really great versus remanding the case. And I have to also confirm that, I have to agree that the landlord did provide the heat to the living room, which was the order of this tonight's hearing appeal. Thank you.
Commissioner Kerpes?
So you're right in that either one will result in the same thing. The only difference is that both of these, the remanding or the waiving the 6 months, under your idea, would result in the same thing, that they would end up in front of the hearing examiner, except the difference is that the hearing examiner or the tenant shows up now under the waived 6 months with a decision that already kind of halfway decides the case. It puts her at a disadvantage. You are right that the hearing examiner may not make a different decision if we just remand it. May review it and say, you know what, they did it. They blew the heat into the living room. But the difference is that he gets to make it on having the full scope of information and having the tenant and landlord provide evidence. We don't get that. We're making this decision without the evidence of the landlord and tenant. So we're depriving both ourselves and the hearing examiner of that evidence. If we remand it, the hearing examiner is open to that evidence and can decide whatever they decide. And if we send it remand, or if we don't remand it and we just waive the 6 months, then we are, I believe, disadvantaging the tenant. And correct me if I'm wrong, but I don't believe, I believe under an appeal, everything is frozen right now anyway. So whether we remand it, if we remand it, she pays the same amount of rent that she pays today, or if we affirm, then, well, I guess then she'd pay more rent, but I can't remember what my point was, but no one gets harmed by us remanding it back, is my point.
I think at this point, I think we've all pretty much expressed where we stand. I'm going to suggest that we make a motion, take a vote, and see where that leads us, whether we need further discussion. So with that, Commissioner March, do you want to take a stab at it?
Sure. I'll make a motion to adopt resolution RSC 20-577, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision on D-4155CD4, 969 North Larrabee Street, Unit 13, amending the resolution to waive the 6-month waiting period for the tenant to refile on the same issue.
Is there a second? Okay, we have a motion and a second. Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity, absent. Commissioner Kirby's,
No.
Commissioner Maggio,
Yes.
Commissioner Martz,
Yes.
Commissioner O'Keefe,
No.
Vice Chair Topchian,
Yes.
Chair Bergstein.
Yes. I believe that passed 4-2. Am I correct?
Yes.
So
Before we go, I've amended the resolution. I just want to make sure that the wording is correct, if that's okay for me to share my screen and do that. Is that Chair Bergstein? Is that okay?
sure,
If I
yes,
do
I'm
that?
sorry. Yes. Couldn't hear my head rattle.
So I've added this bullet point here.
We can't see it. We just see the title.
You can't see it?
No.
We just see the header, nothing else below it.
Okay, so here's the wording that I've added. The 6 months waiting period to apply for a rent adjustment on this issue is waived.
Should it maybe say what issue instead of this issue on the issue of the wall heater?
Sure.
Number of issues originally.
Well, the only issue was the wall heater, but I'm happy to do that.
Oh, yeah.
That is,
On the deal.
On the issue of the wall heater.
okay. Somebody can bring back your faces for me.
Oh, stop share.
Thank you.
I guess
I'm going to suggest that we take a 5-minute break. I'm a little parched, need some water. Come back at 8:58.
Allison? Are you still on
I
here?
am. I'm here.
Oh, I just wanted to give you a heads up. I am probably, and if you can point it out to me, that's fine too, but I am going to have a question about documents in the next one. I just want to give you a heads up. And it's what I'm looking for is oh gosh. I'm looking for
I know.
the evidence, I think. I'm looking for the evidence that the decision was based upon. So we have a determination hearing, but there's nothing, or I mean a determination decision, but not.
So there was no objection. So normally what you would see is the request for a compliance determination, and then the tenants.
Do they have like a form or something where they attach receipts for the city to see?
Correct. Correct. And unfortunately, we could not find that. So all we have is the evidence that was submitted with the determination itself.
Meaning what we have, right?
Yes, what's in the packet.
Okay. All right. Thank you.
Yeah.
I heard the little ding.
Yes, that was me. Sorry.
No, I was in my kitchen. I heard it. It was good.
Sure. Vice Chair Topchin, are you back on the call? Commissioner Maggio?
I'm here.
Thank you. We're all back. Mr. Schulli, are you with us? Mr. Schulli, are you still on the call?
Yes, sir.
Okay. Mr. Dombrowski, I can see you. You can still hear us? Yes? Okay. So with that, I'll call the meeting back to order. We're now going to move on to appeal number D-4287 CD3, 969 North Larrabee Street, unit number 1. Appeal was filed by Ms. Dombrowski, who is present, and Mr. Schulli is here for the property owner. The process will remain the same as the prior appeal. Ms. Regan will make a presentation to the commission. Commission will have the opportunity to ask questions of Ms. Regan. And then we'll start with your testimony. So Ms. Regan, you have the floor.
Thank you. This is an issue that has been before the commission before. This is about the exterior paint on the building. This was in front of the commission last year, and on appeal from the landlord, the hearing examiner had denied the request to restore the rent on the exterior paint. But the issue was that most of the paint had been done except for the doors and some framing. And so the commission partially restored the rent, left in place a $10 rent reduction. And that is what the landlord has requested to be restored here. The city sent out the notices to all of the tenants, letting them know that the landlord had made this request. None of the tenants objected, unlike the previous times, and so the rent was restored. Following that, we received an appeal from Ms. Dombrowski, claiming that she did not receive the notice. We looked back at the records, and the city did indeed send the notices out to all the tenants, and so therefore staff is recommending affirming the hearing examiner's decision, or the decision to restore the rent. Thank you.
Do we want to hold for 1 minute? I see Commissioner Maggio left the screen. And we're back. Commissioners, do you have any questions for Ms. Regan? Commissioner Kerpes.
Did you have a question about there seems to be two in the record. There's two decisions, compliance determinations in there. I understand that they're in there because one mistakenly said the $28 and one was corrected, but the corrected version gives them until March 11th to appeal, which she did. I'm sorry, file, which is the same date that she appealed. So how does that play into this?
Right, so she appealed it properly, but she did not object to the work performed notice. So the appeal is properly before you.
Thank you.
Commissioners, questions for Ms. Regan? No questions? Okay. Ms. Dombrowski, same as last time. If you, let's see, unmute yourself first. Unmute yourself.
Yes.
For the record, I know again, but state your name and city of residence.
Okay, my name is Romita Dombrowski and I live in West Hollywood.
And then again, as the appealing party, you have a total of 5 minutes. You can split your time up between your initial comments and then rebuttal. How would you like to divide your time?
I'm going to do it like half and half.
And half? Okay, you may begin.
Okay, so the issue is that we tenants did not receive the letter that the work was performed by the landlord, what was apparently sent out on January 23rd. So we could not object the request for restoration of the rent by February 6th. And I think the issue is that the letter only went to Brian and Sultan, who initially filed the appeal. And on February 20th, we received the compliance determination with the wrong amount. And after this, me and my neighbor, we called Mrs. Barino from the legal department and asked her why we didn't get the letter, the work performed by the landlord. And she confirmed and told me that she is going to send out a new letter where we have time to object the request by the landlord, but we never received that letter. We only received another compliance determination. And as I said, me and my neighbor, we called in to ask why we did not receive the letter. And also on the latest notice from the appeal, there's a different zip code on the envelope, and on the original letter, what we got from the compliance determination, it only says tenant and not to what tenant was sent out. So, yeah, and so some other issues, it's not just that the door frames were not painted, it's also my balcony exterior has not been painted, and in front of my entrance, the walkway, there are paint splashes all over, 2 different colors of paint, and everything is cracked and broken. That's it.
Okay. Mr. Schulli?
Yeah, first of all, I would like, this is Brian Schulli, resident manager, 969 Larrabee. I also live here on the property. So to the point that the letters were never received except for from Sultan and myself, I would argue that I received the same letter that addressed to tenant. The external management company, the property owners received one addressed to management, and Sultan also received one as tenant. And I know there were other tenants who had asked me questions specifically about it. So I know that multiple tenants received the same communications. As far as what she was just referring to, Ms. Dombrowski said that there were 2 different colors on the walkway and it cracked. That is actually a new problem that has come along. We discovered a safety issue in the walkway that is in front of her apartment, and we tore up the decking and replaced it. So that is not the same paint that was done as part of the compliance determination. We just did this about 6 months ago. That we tore up that walkway, and that's why it's a different color, and that's actually in the process of being completely redone over again to smooth it out to a finished product with the entire walkways. But my point to that is it's not part of the painting that she's claiming was not done. As far as the frames for the windows, you know, the windows are aluminum windows, and you don't paint aluminum windows with the same paint that you would use on stucco. So I don't, and none of the aluminum window frames had been painted. So I don't understand why that would even be considered. So for those reasons, I would say that, and the doors, as far as the doors, what she's referring to was a strip around the doors where they had been closed when the painters were here. And so when you open the door, you could see a ring of the old color. And that has since been also resolved. So I don't see how that's even a concern anymore either, which was part of the compliance determination. There was only one tenant's door who had not been at the time done. It was because he refused us access to the door to do it. But he has since allowed that, and it is corrected. And that's all I have.
Mr. Secretary, how much time does Ms. Dombrowski have left for rebuttal?
Yes, 3 minutes and 13 seconds.
Okay.
So the landlord filed the request for compliance to restore the rent on January 23rd, and the door frames were actually not painted until February 7th. And as I said, we never received the notice. My neighbor also called into the legal department that we did not receive that. This is the first time, or everybody on this floor here, I'm on the second floor, did not receive the notice. So I'm wondered who received the notice, what Brian mentioned. I'm not talking about the aluminum frames, which were painted because it was based on there was inside work or interior paint being done. And it was also not only the door frames, it's also the floor for my balcony was not painted, and everything in front of my door in the bottom on the floor was also not painted, and also the doors and the door frames. And they did not solve this issue. I mean, the balcony floor is still not painted, but the door frames were not painted until February 7th. And yeah, that's it.
Thank you. Commissioners, do you have questions for either of the parties? No questions? We'll begin commission deliberations. Commissioner Kerpes?
Questions for Ms. Regan first about what evidence we can weigh this evening, because it's my understanding that we would only be able to weigh evidence that was, or can you tell me what evidence I can weigh this evening, because both sides, I feel, said information that I can't weigh.
That's right. The issue really is whether the city provided the notice in a proper manner, because there was no objection filed.
So based upon that, it sounds like we're considering the signed affidavit from the signed documents from the city staff that through their procedure, when they mail things out, they sign the form. We're weighing that with the tenant's testimony of not receiving it, and we're weighing the landlord's. Actually, I don't really even think we can weigh the landlord's testimony, because it would be new testimony. The testimony that he received it or didn't receive it would be not something that we could consider, because it's not in the record, right?
Well, because this would not have been, this is one of those things that could not have been considered earlier, since no one knew at the time that this claim was going to come up. So as far as that narrow issue, you can.
Okay. And just for the record, because I have already asked you off the record during our break, but just for the record so I can ask it, do we have, I know that the compliance determination is signed and in our packet. That is the determination, but we don't have anything to see what was decided, looked at and reviewed, and how that decision was made, do we?
Correct.
Those are my questions for now.
Commissioner Maggio?
Well, it sounds to me that many of the areas have been skipped. If it sounds like the tenant's balcony is not completed and all these door areas. So I don't understand how we can restore rent if the job hasn't been truly completed. So I kind of am thinking that the work has not been completed, and until it's really completed, I can't imagine why I would want to restore rent.
Ms. Regan, just to clarify, I don't think that's the question before us tonight. The question tonight is, were the tenants noticed?
Correct.
So we're not actually talking about the scope of the work and whether the work was completed. We're only discussing whether they were noticed, correct?
That's correct.
So the testimony that I probably should have stopped earlier on from both parties about what was and wasn't done is completely irrelevant to tonight's discussion. Commissioner Maggio, does that change the comments that you wish to make at this time?
I feel that there has been enough noticing, and I'm glad I made the prior comments too, but I think there has been appropriate noticing.
Commissioner Martz?
I would agree with the staff report's recommendation. We have a very limited amount of information to go on, but what we do have to go on is the legal services or the staff's statement that they checked their records, it was appropriately noticed. Do mistakes happen? Sure, but they noticed other things appropriately. I can't see 13 units or whatever the number is here just being missed. So based on their statements, I think we have no choice but to uphold the staff report's recommendation.
Commissioner O'Keefe?
I have a question for Ms. Regan. If I found Ms. Dombrowski's statements credible, which we're allowed to consider, because this isn't something that could have been known at the time of the compliance determination, then, and if I found them credible and believe that she did not receive the notice and that she knows of other people that didn't, even if I also have no reason to doubt and believe that it was sent out, then where does that leave me? Do I have to found everybody received it to uphold it, or just that it was sent out even if something happened and it didn't make it to the recipient?
That's correct. Just that it was sent out as we were supposed to. Personal service is not required.
Okay, well, for that reason, then I would agree with staff and uphold the decision. I don't doubt that Ms. Dombrowski didn't receive it, but I also have no reason to doubt that it wasn't actually sent out, even if something happened and it got delivered to the wrong address or something else went awry.
Vice Chair Topchin?
Thank you, Chair. Well, on the issue of that notification to the tenants, and I agree with staff, and I'm going to affirm that staff's recommendation. But again, I know that is not before us right now, but before us tonight. But since the tenants made the statement, so it's kind of stuck with me, and it's here on the record. So what needs to be done in order to fix those things that are areas that are left out without painting? The floor, the stairs. I know that's not the issue. As I said, I'm going to vote to support. But what is the process? Maybe Ms. Regan can explain. So what needs to be done here in order to address those issues before the rent can be fully restored? Or if the rent is restored and the areas are not painted?
Yeah, that would have to be, if that is the belief, that could be brought as a separate issue.
As a separate rent decrease issue again?
Yes, but bear in mind, this is a compliance determination.
Right, I get it.
Yeah.
So, and yeah, and I'm, as I said, I'm fully, I'm in agreement with staff's recommendation. I'm going to support that. It's just I was curious about the other issues.
Ms. Regan, I also have a question. You can tell me I can't ask this question, but would this be an instance where if we uphold the hearing examiner's decision, we could waive a 6-month period to refile for any of the work that the tenant may be claiming has not been completed? Or would that be a separate issue, or can I not ask that tonight?
You can ask it, but I would just be very careful with that, because this is a process where we want the tenants to avail themselves. No tenants objected to this, so I would be very cautious in doing that unless there is some compelling reason to do so.
I would think that might be correct, because as you said, none of the other tenants have complained about this. So I didn't see whose hand went up first. Commissioner O'Keefe?
I would find these to be compelling circumstances, because I do have no reason to doubt the credibility of Ms. Dombrowski's testimony. So even if the city technically satisfied the notice requirement, if I believe, and I do, that Ms. Dombrowski didn't actually receive it and have the opportunity to complain, and she now is saying that the work wasn't done in front of her unit, it seems like it would be unfair to make her wait for 6 months to file again, given that she, and I believe, didn't receive the notice even if it was sent.
Commissioner Kerpes?
So I'm weighing whether, the signed affidavit saying that it was mailed, and I'm weighing the credibility of the tenant. I don't doubt I have no reason to doubt the credibility of the tenant. While I have no reason to doubt Ms. Berenger, I believe is her last name, her in particular, I know from past experience that the city has not sometimes complied with certain items on a rare occasion. And I know that humans make mistakes. And I know that that form that she signed, it's the very last thing is tenants are kind of grouped together, and it's like tenants like 2 through 16 or whatever it was. To me, there's less accountability. It's different if I say I sent it to unit 2, I sent it to unit 3, I sent it to unit 4. But the shorthand of sending it to tenant 2 through 16 or whatever, unlike the owner got sent and the management company got sent a letter. Again, that probably works 90% of the time, 99% of the time. But I'm weighing those two things. So what it comes down to me is, do I feel confident enough that I can make a decision that's going to not put the tenant, again, in a position where they're lost. I don't see somebody, there's already a compliance on the record that they have painted as the order required. So how could she possibly bring up the same issue and have another trial or another hearing and come up with a different, I mean, it's not even like as complicated as the last one. This one is very simple, the decision, the determination. And so then I refer to the determination and how the determination was made. And because I have no evidence on the determination, no receipts, I didn't get to see what the person making the determination in this got to see. That I question that. So it's a minor thing, but if I'm between the two, I just have to go with the non-government agency, and I don't want to always side with government just because it's government. I'm going to go with the tenant.
Commissioner Martz?
I respectfully disagree with Commissioner Kirkby. I don't think most of that is relevant to tonight's discussion. The question is whether the tenant provided notice to the city in time of an objection, and the answer is no. And the question again is, did she get notice? We have the landlord saying that he received it, the tenant saying she did not, and we have city staff saying they did. I don't see a reason for us to waive the 6-month rule. I think it's a very clear case, so I am in favor of the staff's recommendation as written.
I would agree with your comments and the fact that the process the city uses for noticing the parties was not deviated. This is our standard process for every single case that comes through the desks at City Hall. So there was nothing new and unusual. So I would disagree with Commissioner Kirkby's and Commissioner Martz. Any further comments before we call a vote? With that, then we have a draft resolution, RSC-20-576. Would someone like to make a motion? Vice Chair Topchin? No. Commissioner Martz?
Yes, I will, if you give me 1 second here. Switching screens. All right, I'll make a motion to adopt resolution RSC 20-576, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision on D-4287 CD3 at 969 North Larrabee Street, unit number 1.
Do we have a second? I will second the motion. That, Mr. Secretary, can we have a roll call vote, please?
Commissioner Charity is absent. Commissioner Kirby's?
No.
Commissioner Maggio?
Yes.
Commissioner Martz?
Yes.
Commissioner O'Keefe,
Oops, I'm muted. No.
There you go.
Vice Chair Topshin,
No.
Chair Bergstein.
Yes. I think we have a 3-3 vote.
Yes.
Ms. Regan, that's a first for me in this.
So the decision stands.
Thank you.
Doesn't the motion fail? Oh, we were not able to overrule it or something, right?
Yeah. So for both parties, thank you for your patience this evening online. Again, if you have any questions, you can call City Hall at 323-848-6450 or email rsh@weho.org if you have questions about any of the 3 appeals from this evening.
Thank you. Have a good night.
Matt, you are welcome to log back in on Zoom, but we're going to remove you from the waiting room. We'll continue our meeting. And with that, we'll go to item 10, new business. I'm not aware that we have any new business. Mr. Noonan. Going on to item 11, Mr. Secretary, do we have any public speakers at this time?
Not at this time.
Thank you. Going on to item 12, any commission comments? Mr. Martz?
2 quick comments. I have a request for staff when they put together our packets. I don't know if it's possible or if it's too much work, but it would be very helpful to me, since we're doing this all online, to have a table of contents or something, basically saying this is where this appeal starts, page 200, whatnot, because going back and forth, sometimes I lose my spot. And if I had a table of contents that could direct me, that would be really, really helpful. My second comment is I just want to note that Commissioner Charity is not here because he was in a car accident. He is fine, but his car is pretty banged up, so he had to deal with all of that right before this meeting. So he wanted to pass along that he's sorry for missing. He's fine, don't worry, but he sends his hellos. That's all I have.
Glad he's okay. Cars can get replaced, health cannot.
Exactly.
Commissioner, was your hand? Did you want to make a comment? Yes. Commissioner O'Keefe.
2 things. First, I went to virtually the Public Safety Commission, their last meeting as our liaison, and let them know about all the wonderful things the city is doing to try to keep people housed during the pandemic. Second, this case, the most recent one, made me wonder if perhaps the city could provide notice to all parties that want to by email. I think this is worthwhile during all times, just because it's a little easier to track and see that the email address was precise. You have a better record, it's immediate. For those ones, the initial notice might have to be by mail, but those that want to write back and have their email so they could be notified in the future. And unfortunately, it seems like the president is set on destroying mail service, so we have much slower mail service than we once had. That is it for me.
Outside issue, outside issue.
It's relevant though. It's if we're notified by mail and it takes 15 days, it's a problem.
I'm sorry, I was thinking the exact same thing, just didn't vocalize it. Commissioner Kerpies?
Yeah, I would like to ditto that. The U.S. Post Office has been unreliable for a long time. I don't want to blame them, but yeah, especially now with the changes being forced upon them. I want to thank both the tenant and the landlord tonight. Both of them in both cases were respectful to each other and with the exception of this last case, but I think all of us were just as confused. We're very good about staying to the facts of what was at issue, and it's been a while since we've seen both parties be so cordial to each other. And this is an issue that's been going on at this location for quite a while. So I'm glad that as long as this has been going on, that they are still able to come and present themselves in a cordial way to each other. And then I also want to remind everybody, I'm sure everyone here is probably sick of hearing it, my2020census.gov, please go there. Hopefully you can still see me, my battery's dying. Please go there if you have not already and get counted. This is for the census. West Hollywood is at a measly 58% response rate. In 2010, we had a 67.8 response rate. The county is even higher, the county and the state both have a higher response rate than we do in West Hollywood. which is shameful because we are active and involved and have high turnouts compared to other areas of the state when it comes to voting. And this is really important that we get counted. And that's all I have to say. Oh, right now we rank 232 out of 292 cities, which is just embarrassing. So tell your neighbors, tell your friends, tell your parents, tell your kids, whatever it is, get them online, my2020census.gov. It only takes 5 minutes. Thank you.
Commissioners, any other comments? Commissioner Kurbis, I would just say that sense of civility and politeness, let's hope that extends to our city council elections coming up this November. That would be nice. Moving on to item 13, staff comments. Mr. Noonan.
Just to say, be safe, be well, and I think it was a great meeting. Thank you all.
And with that, we will adjourn tonight's meeting to the next meeting of the Rent Stabilization Commission, which will be held 7 p.m. Thursday, August 27th via teleconference. Adjourned. Thank you.
Good night, all.
Have a good night, all.
Everyone.
Hello, WeHo. It's Eddie Robinson from WehoTV News. Do you have a play, dance, poem, exhibit, or arts presentation that you would like